And the PowerPoint, as I go through it, will point out exactly what I'm talking about. Christina, Ms. Carroll, can you share your screen?
Yes.
She's more adept at this technology than I am, Judge.
No problem.
Okay. Okay, let's go to the next slide. Your Honor, based on the plaintiff's amended petition, which they amended after we filed our initial Rule 91A motion, we filed an amended 91A motion following that. The amended petition lays out what happened here. In summary, Mr. Williams, as next friend for his adult daughter, Miss Ashton Williams, who was assaulted, sued Amazon for the criminal conduct of the individual defendant, Mario Carranza. He planned and executed a terrible scheme. He interdicted Miss Williams prior to her clocking in for work at Amazon on August 25th, 2023, then induced her to accompany him in his personal vehicle to a restaurant for lunch. Then afterwards took her to a hotel where he sexually assaulted her. According to the plaintiff's amended petition, Carranza committed false imprisonment and sexual assault, and the plaintiffs admit that those are crimes. Next slide, please. Here are the critical facts, Judge. Amazon is not liable, jointly or severally, or vicariously, for the personal criminal conduct of defendant Carranza. He intercepted Miss Williams before she clocked into work, took her off-site in his personal vehicle, assaulted her after lunch, and the plaintiffs pled that Carranza had a, quote, specific intent to cause substantial injury, close quote, during his criminal acts. There is nothing about what Carranza did that was believably within the course and scope of his responsibilities, nor was anything that he did in this course of conduct in furtherance of Amazon's business.
What is Mr. Carranza's, is he Miss Williams' supervisor, or what is his role?
The plaintiffs pled that Carranza is a supervisor, and this is not for consideration under Rule 91A, I understand, Judge, but on our records, he is not a supervisor. He's a colleague. There's some pleadings here that kind of get to the edge of the envelope here. But irrespective of that,
Your Honor, may I respond to that?
If Judge, if I may complete my argument, I'm sure you'll allow plenty of time for it.
Yeah, Mr. Hunter, we'll get to you in a second.
Thank you.
Thank you, Judge. Irrespective of that, conduct that takes someone off-site for criminal conduct it would just be extraordinary to make the company responsible for that. Next slide, please. Under Rule 91A, Judge, you know the standard. There's no basis in law where the plaintiffs failed to plead a legally cognizable cause of action, and the allegation in plaintiff's pleading established a complete legal bar to the plaintiff's claims by affirmatively negating entitlement to the relief requested. And there's a no basis in fact standard as well, Judge. Next slide, please. So we've got two levels of reasons why this case should be dismissed. Regarding all the claims, intentional torts of false imprisonment and sexual assault, and all the negligence claims, training, retention, and supervision should be dismissed because criminal conduct vitiates the causal connection that could tie the company to any liability in this case. In addition to that overriding basis for dismissal, there are specific bases that lead to dismissal of the individual claims for negligent training, retention, and supervision. There's no proximate cause because there's no foreseeability here that Carranza was capable of or likely to commit a violent crime. There's some allegations plaintiffs have made, but they are distinct in type and severity about Carranza's background that do not create foreseeability.
What exactly did they allege?
They allege that there are reports of Carranza's sexual harassment of colleagues at Amazon. None of those allegations say that there was any physical violence or any physical contact with the victims, the alleged victims. Again, off the record here, we have to date found nothing regarding such reports. But again, that's not within the scope of a 91A motion. The Texas Supreme Court has held that domestic disturbances and theft do not make foreseeable violent crimes. This Court of Appeals has held that when there is excessive drinking by persons who then sexually assault someone, the sexual assault is not foreseeable. What's alleged here in terms of the conduct or some complaints against Carranza at Amazon are sexual harassment. They're conclusory comments. We don't know if they're comments that were made or if it was emails that were sent. We don't know, just a conclusory assertions of that type, Judge, but they do not involve anything like the horrific false imprisonment and sexual harassment, sexual assault that was pled here. So they're not foreseeable, Judge. And that, again, triggers the vitiation of causation because of the commission of a crime. And then, again, that takes care of all of the claims. On top of that, negligent training, there's just no facts pled that suggests there's any basis for holding Amazon liable for negligent training. Next slide, please. And let's go into the second half of the slide as well. Okay, here's some of the case law. It's in our briefing, but just to emphasize, Judge, third parties' criminal conduct is a superseding or new and independent cause and not reasonably foreseeable. In addition, such action, looking at the patent case at the bottom, is not in furtherance of the purpose of carrying out the business. And such actions like sexual assault are intensely personal, not connected to the company. Next slide, please. And here's the case law on foreseeability. Boss versus Smith, Texas Supreme Court, 2018, for behavior to provide notice, be foreseeable for violence later. It must be so similar in character and severity to what came before as to be foreseeable.
I mean, isn't sexual harassment and sexual assault, I mean, fairly similar? And what exactly was pled as to the sexual harassment?
Okay, Judge, I will let you know here as to those. Now, they both involve potentially some sexual animus, but in terms of the proclivity or propensity of a person to commit violence, that's a different animal, Your Honor, different type and severity from a sexual assault and from physically taking someone basically to akin to a kidnapping. Here are the pleadings. Paragraph 18 of the amended petition. Multiple female Amazon employees had accused Carranza of sexual harassment and inappropriate behavior. Paragraph 14, Lewis, the plaintiff, Lewis Williams, learned from a security guard Carranza had faced complaints and investigations, okay, regarding, let's get the rest of that, harassment and inappropriate conduct. Nothing here suggests that Carranza is a violent individual who has a proclivity or
I mean,
could in the future commit violent crimes.
Let me ask this. Have you filed a special exception in this case asking what all this means? Because it's sexual harassment, it's inappropriate conduct. Inappropriate conduct could be anywhere from commenting on somebody's weight to, you know, exposing yourself at the workplace. I mean, all of that's inappropriate conduct. It's not, we don't really know what that is, right?
Your Honor, you know, if there was violence committed by Carranza at Amazon,
this isn't just a crime of violence, it's also a crime of genetics.
There is, Your Honor, that's correct. But it's the plaintiff's burden to make allegations that survive a 91A motion. In fact, Johnson Court in 2024, Fort Worth Court of Appeals cited in our briefing, the quote is threadbare recitals of the elements of a cause of action.
Is there any cases out there by the Supreme Court or Dallas Court of Appeals that have had somebody who's been accused of multiple instances of sexual harassment, who later went on and committed a sexual harassment or sexual assault, and that wasn't enough under foreseeability. Are there any cases that say that? Because I mean, I agree that prior domestic disturbances, vandalism, and theft probably would not put you on notice that they'd commit a sexual crime, but multiple instances of sexual harassment, inappropriate conduct, investigations. I mean, you're right now trying to cut off all discovery into by Mr. Honeycutt's client into looking into any of this stuff. So he's pleading what he's got. Any cases that say that that should be dismissed on a 91A basis?
Two cases are particularly important here, Judge.
Okay.
Frith, F-R-I-T-H versus Fairview Baptist Church out of the Dallas Court of Appeals in 2002. Petition was denied at the Texas Supreme Court. In that case, a Sunday school teacher with a criminal history of 3 felonies and 5 misdemeanors, as well as a protective order for physically abusing his own child, sexually assaulting a minor child, was charged with sexually assaulting a minor child through the church. Despite his criminal history, the Dallas Court of Appeals found that, quote, none of the defendant's convictions were for violent or sexual crimes, and nothing in his background indicated that he might sexually assault a child. Your Honor, generic misdeeds cannot make foreseeability.
But these aren't generic misdeeds. These are claims of sexual harassment. These are not claims of, all right. Anyway, I don't find that case is clearly distinguishable. What about the other one?
Well, Judge, if I may just add, the plaintiffs have not alleged that there was any violence committed by Carranza on site. They've alleged sexual harassment and nothing involving violence or attacking or kidnapping persons prior to this event. There's another case, Golden's Bread Council, out of the Texas Supreme Court in 1996, which the plaintiffs rely on, but it's actually easily distinguishable. In this case, it's undisputed that the scoutmaster was a molester of boys. And then when he went on the council and had contact with the scouts, he then molested a boy, and that was found to be foreseeable. But what's different there about this case than compared to this case is the scoutmaster was undisputedly a molester. He then committed molestation again. Difference between casual comment, maybe an email, inappropriate, bad, shouldn't be done, compared to committing a crime. And again, there's no allegation in the plaintiff's amended petition that Carranza committed any crimes or attempted any crimes while at Amazon. I'll move on to the next slide, Your Honor, unless you have any more questions about that.
Go ahead.
Okay. Okay. And to reemphasize, there's no allegation in the amended petition of any criminal conduct in furtherance of Amazon's business. No notice of any crime for Amazon related to Carranza on the workplace. Next slide, please. And we'll move promptly through these, Your Honor. Okay. And this is authorities that reinforce some of the things I've said already. In the interest of time, we'll move forward to the next slide. Okay, next slide, please. Again, reinforcing the lack of facts. And this slide, number 11, I'm going to ask, Your Honor, if Ms. Carroll may succinctly address this issue.
Yes, Your Honor. Good morning. So plaintiff has argued that that Amazon is liable for Carranza's act through apparent authority. But as we've established both in our pleadings and then in our motion and then today, apparent authority is another vehicle of vicarious liability. And so for the same reason that vicarious liability fails on its own, so does apparent authority. Now, what's important is that apparent authority still requires the acts be committed in furtherance of Amazon's business. There are no facts that plaintiff has pleaded to show that Carranza's, that his false imprisonment or his sexual assault were in furtherance of Amazon's business. The case law is that the tort must grow out of Amazon's authority to perform Carranza's duties, or stem, that the tort must be that, I apologize, I'm tripping over my words here. The law is that Carranza's tort must grow out of his authority granted by Amazon to perform his duties, or the torts must stem directly from his delegated duties. And so there's no facts that Carranza's job duties included use of force or sexual assault or false imprisonment. There's a case that we cited, it's Mastech v. Harris. And in that case, it was an installer who came to the house of a customer and assaulted her. And the court said that it wasn't the reason, the proper focus wasn't the reason why the installer was at the house. The proper focus was the assault, was the sexual assault. Did that stem out of his job duties, the installer's job duties? And it did not. And the same issue here. The sexual assault and false imprisonment don't stem from Carranza's job duties. And then in terms of apparent authority specifically, only Amazon's conduct can be considered when we're determining whether Carranza had apparent authority. And what Carranza may have represented to, what Carranza may have represented to Ms. Ashton Williams is irrelevant for purposes of apparent authority. When you have authority, it's either actual authority, which is the authority that Amazon grants to Carranza, or apparent authority, which is what Amazon represents to here, Ms. Ashton Williams. In both instances of authority, the question is, what did the employer do? What was the employer's conduct? There are no allegations that Amazon represented or caused Ms. Ashton Williams to believe that Carranza had the specific authority to falsely imprison her and to sexually assault her as part of his job duties.
Okay.
Thank you.
All right, let me hear from the other side.
Thank you, Your Honor. Well, there are some critical facts that counsel has left out of their arguments. And that is that Amazon gave Mr. Carranza, a known sexual predator, unlimited supervisory authority over Ashton. That is what was pled. And that Amazon knew that she had the intellect of a young child. She did not have the capacity to consent to anything. That is what was pled. And so using that authority and in reliance on the training that Amazon gave both of them, Ashton followed the directives of her supervisor to go with him and let him perform these unspeakable acts, because Amazon trained Ashton to go and do whatever her supervisor told her to. And it was Amazon that told Carranza that she would go and do whatever he told her to do. And regarding the issue of foreseeability, Your Honor, I think Your Honor is correct that sexual harassment does cause a foreseeable risk of sexual related harm. And I would like to correct some of the arguments made, particularly Golden Spread Counsel. The ultimate ruling there was that Golden Spread Counsel only knew that the Scoutmaster was, quote, messing with some Boy Scouts that, quote, might be serious. So the Scoutmaster being a known molester is not the ultimate holding in that case. And yet that was enough to create a foreseeability issue as to the...
Had the Scoutmaster in that case been convicted of sexual molestation before?
That was not within Golden Spread Counsel's knowledge. Okay. I'm not sure. I don't recall if he was convicted previously for that, but in any event, that was not within the employer's knowledge yet. Those bare allegations were enough to hold that they had a foreseeable risk. And regarding counsel's statement that there has to have been prior physical violence, that's simply not true. In Massage Heights Franchising versus Hagman, the Houston Court of Appeals held that it was foreseeable that a masseuse would sexually assault a customer based on the employer's prior knowledge of his non-sexual and his offenses regarding robbery and burglary and evading arrest. So we're not talking about sexual violence in his past either. Yet that was enough to hold that the harm was foreseeable. And
regarding this, I'm sorry, go ahead.
Well, regarding apparent authority, Amazon keeps conflating the issue of actual authority and apparent authority. We have pled that Amazon gave specific directives to Ashton that raised the issue of apparent authority. She was simply told that her supervisor would show up, tell her where to go, and tell her what to do. That's it. That was the extent of how she was trained in our pleadings. And so that's exactly what she did. She relied on that as a person without the full mental faculties to know that there was anything amiss. She relied on that authority that Amazon clothed Carranza with. And so therefore, Amazon did cause Ashton to believe that Carranza had the authority to take her off site and commit those acts. And Amazon's reliance on Mastech and the Zaranza case that they put onto the slide are misplaced. Mastech didn't involve apparent authority. It didn't involve a victim who was an employee who was instructed by Mastech to follow the directives of their cable installer. And Zaranza also did not involve any representations made by the employer to the plaintiff. The victim relied solely on the representations from the perpetrator, which was not enough for apparent authority in that case. So all in all, Your Honor, we have pled more than specific facts that state claims in the amended petition. They have basis in law, and these are believable claims, and the motion should be denied in whole.
Let me ask a question. Have you guys submitted a binder for me? Because I know this was amended and everything.
Yes, Your Honor, we delivered one on Friday.
Okay, with all briefing on both sides?
Yes, at the briefing that was available then, there was a late filed reply brief from Amazon that was filed later in the day on Friday, but that wasn't within the 3 working days under local rules.
Okay.
Your Honor, we submitted a binder to Your Honor as well that includes our reply, and then as well as the highlighted cases that your rules require.
Okay.
And if I may, you had asked a question about whether there's case law that shows sexual harassment doesn't make sexual assault foreseeable. And there is a case that we cited in our reply that I'd just like to bring to your attention, if that's okay.
Sure.
It's the Macon versus Brahms case. And we cited it at the end of our reply. And essentially, it's 2 employees. One employee sexually assaulted another. The perpetrator there was a sex offender, and the court still found that there was no foreseeability.
Your Honor, I need to reply to that, please.
Okay.
In the Macon versus Brahms case, the employer was not imputed of having any knowledge of the perpetrator's prior sexual offenses. The whole point of that case was that the employer did not have a duty to even check the sex offender registry. And also, this was not, the perpetrator was not somebody that was clothed with the authority of a supervisor by Brahms. They were merely coworkers who met at work. So it's a very distinguishable case in this one.
Okay. When is the when is the final date that I have to make a ruling on this?
Your Honor, I will give me 1 second to check.
Your Honor, I believe it's May 19th.
Yeah. And Your Honor, we'll confirm that by email, sir.
All right, by May 19th. Okay. Is that even with the amended motion? That's the deadline?
That's my understanding, Your Honor.
And Your Honor, that's in my notes rather than burden the court with waiting while I plow through them. We'll forward that to your clerk and copy the other side just to confirm. And Your Honor, if I may, just one quick case to also take a look at. I cited it, the Frith versus Fairview Baptist Church out of the Dallas Court of Appeals. You heard an argument that the distinction between violent and nonviolent conduct is immaterial. Well, in that case, recall, there was a school teacher with a criminal history of felonies and misdemeanors. And despite his criminal history, the Dallas Court of Appeals found, quote, none of the defendant's convictions were for violent or sexual crimes. Nothing in his background indicated he might sexually assault a child. The distinction between generic sexual harassment and violence is important. The Dallas Court of Appeals has acknowledged that.
Okay, great.
Your Honor, may I respond to that, please?
No, this case has gone way over. I have the binders. We'll get you email Rhonda with the exact date that this, and confer with each other on this, because it doesn't do anyone any good for me to have the wrong date. So confer with each other, try to work this out, and then send me a joint email saying the date you need to make a decision by is X, and then ask her to forward that to me. Okay.
We'll do that, Your Honor.
Thank
Thank
you,
you
Your
for your time this morning.
Thank you, guys. You have a great rest of your day.
Thank you, too, Your Honor.
All right. Are both sides here on Lalani versus Huss?
Your
Lalani,
Honor.
okay.
I am, Your Honor. There we go.
Anyone else on this case?
It's just us, Your Honor.
Discuss.
Okay. And you guys are set for trial on
June 3rd.
June 3rd. Okay. All right. This case is almost 2 years old. So I'm sure you've heard the speech from other judges that we have this new requirement that all of our cases are tracked, our continuances are tracked, and they're put on a statewide website. And if a case goes over 6 to 12 months, 12 to 18 months, 18 to 24 months, this case is getting pretty old. And so just wanted to kind of chat with y'all about this and find out what really needs to happen before you guys go to trial.
Yes, Your Honor. I think I can answer that. I think we were actually on track. What happened, unfortunately, is Miss Lalani was diagnosed with breast cancer and just finished her treatments in March. It's a complex medical malpractice case. She went in for a sinus surgery and she ended up suffering brain damage. And there is a dispute about how severe the brain damage is. One of my experts has been deposed. There's a total of 9 experts on both sides left to be deposed. I think that the defendants have asked for their neuropsychologist to do a medical exam of Miss Lalani before they are deposed, which I'm not opposed to that. So to answer your question directly, it's to finish the expert depositions, which.
So I'm sorry to hear your client is going through that, but how does that relate to the experts not being deposed?
So because there's a life care plan in the case, and there, I will also tell you, Your Honor, there's a language barrier. My clients are from Pakistan. And so like when I found out she had the diagnosis of cancer, it wasn't very clear to me, how severe the cancer was. So before my life care plan could be finalized, they needed to find out exactly what the cancer was, what the prognosis was, and things of that nature. So those depositions got delayed. And then the defendants also wanted to allow her to get through that treatment before their damage experts did their examination of her and finalized their opinions.
Ms. Buckles?
No, I agree with everything Mr. Brothers said. We do want to conduct an independent medical examination given the dispute between the nature of the brain injury. And that is not something we wanted to put Miss Lalani through while she was undergoing cancer treatments. We want her to have time to recover, get back to baseline, and allow that to proceed.
Okay. And is she done with her cancer treatment now?
Yes, Your Honor. She finished, I think 3 weeks ago was her last treatment.
Okay, and how's she doing?
She's doing well. They caught it early, fortunately.
Good, 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 good. It's remarkable what they're doing with cancer treatment these days. People that it's anyway. I hope everything goes well for her. So when are y'all wanting to reset this to?
I believe in our motion, we had an agreed date of December 15th.
So I guess my concern about that, how long is this case going to take to try? With all, that's a lot of experts.
Yeah, we're probably 10 days.
I mean, you're looking right before Christmas, right? I mean, if it's December 16th, the next week is Christmas, the week after that is, I mean, kind of the courts usually shut down. Do you really want to try this on December 16th?
Yeah, I think that may be optimistic. I'd like a setting before the end of the year. I think we can knock these experts out, fairly quickly, but I also don't want to have to come back and ask for another continuance.
What about December 2nd?
I'd be fine with that, Your Honor.
I do not know our lead trial attorney's schedule at this time, but if that's what the court prefers, then that I'm sure is going to be just fine.
All right, let's go ahead and set it for December 2nd, Rhonda. And have you already been to mediation?
We have not, Your Honor. So they want to depose my experts. Then we said we would go to mediation. If that fails, we'll have their experts already set, and then we'll do their experts before trial.
Okay. All righty, guys. Anything else today?
That's all, Your Honor. Thank you very much.
Thank you, Your Honor.
Sorry for having to file it. I know you guys are under pressure with these continuances.
Well, I mean, there's times like this that I think it needs to happen. So let's try to get this done. Okay.
Thank you, Your Honor.
All
Sure,
right,
thank you.
You have a great rest of your day.
You too.
Okay. Our next case is Reliable Pros Services versus Agility Restoration. Are both sides here in that case?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right.